Moments ago, Karen Reed's answer was filed and publicly available to us, so let's go over it, folks. You must follow the law. The law says...
Glorious. Is it a lawsuit? Probably. Why not?
Well, hello everybody, and welcome back to Buckle Up. It's the Law with attorney Larry Forman. Folks, Karen Reed's team, civil defense team, has finally filed their answer yesterday, October 21st, which has become publicly available for us once the clerk processed it here on October 22nd, and we are going to go over it. Now, for those of you who may not know, the O'Keefe family is suing Karen Reed for her transgressions of the heinous murder of John O'Keefe. Wait a minute. I'm sorry. Did I say Karen Reed? I meant the McAlberts. But, of course, the O'Keefe family, unfortunately, Peggy, Paul, et al., are all pointing the fingers still after not one, but two criminal acquittals in the Norfolk County Superior Court. Folks, we are continuing the saga of the civil case of the O'Keefes versus Karen Reed. Now, this is about 16-page document. There is a lot of, for those of you who don't know how an answer works, essentially the defendant is supposed to admit or deny the claims that were made in the original complaint. And so as you will see, most of the paragraphs are going to be very straightforward. Ms. Reed is without sufficient or adequate information to admit or deny the allegations asserted in paragraphs 1, 2, 3, 4, 5, 6, and 7. Ms. Reed admits only that John O'Keefe, the decedent, had two siblings, that he was a Boston police officer, and that he raised his niece and nephew as their guardian. Further responding to the remaining allegations asserted in paragraph 9 of the complaint, Ms. Reed is without sufficient or adequate information to admit or deny them, and therefore denies the same. And there are some that are admitted, some that are denied. Ms. Reed is also without sufficient or adequate information to admit or deny allegations as to the status of C.F. McCarthy's license to sell and serve alcohol, and therefore denies the same. She admits that she consumed alcohol. So we have an admission. We already know this. This is no surprise that she consumed alcohol at C.F. McCarthy's on January 28th. Ms. Reed admits only in paragraph 20 that she left C.F. McCarthy's with John O'Keefe. Otherwise, the rest she denies, whatever was in that paragraph. Ms. Reed admits only that she carried her drink with her when she departed the tavern, otherwise denied as pled. Ms. Reed is without sufficient or adequate information to admit or deny as to the status of the Waterfall's license to sell and serve alcohol. That's probably what the question prompted, and therefore she denies the same. Now, paragraph 45. Ms. Reed admits only that the decedent was later determined to have suffered traumatic injury. It was probably a request for her to admit that she's the one who caused the traumatic injury, but she's only admitting, yes, he suffered traumatic injury, but not by my hand, by the McAlberts. And we will see them later on being added to the lawsuit as her lawyers, through Damon Seligson in open court, have already admitted the same last month. Now, number 48 is interesting. The written results of Ms. Reed's blood draw referenced in paragraph 48 of the complaint speak for itself, and therefore no response is required. I think it was seeking an admission about her blood alcohol results, and there's no need for them to reassert what it is and what it's not. It's self-explanatory. It speaks for itself. So, like I said, a very, very standard stuff. Count 1, Ms. Reed restates and reiterates everything said in paragraphs 1 through 53, and then we get a bunch of denials. No response required, denied, no response required, denied, just one after another. Counts 2, counts 3, counts 4, count 5. Very, very standard language. Count 6, it's literally just copy and paste job. You're copying and pasting and you're changing the number. This is how you respond to a complaint, folks. If you ever, God forbid, find yourself in a civil situation, first of all, hire an attorney. But secondly, even if you cannot hire an attorney, this is how it's done. Do you need a lawyer that defense counsel fear? Hire me, Larry Forman. I'm a trial lawyer. I know how to get money in your pocket. If you've been injured in any way, shape, or form, car accident, dog bite, slip and fall, medical malpractice, doctor negligence, hospital negligence, whatever it may be, give us a call. 1-844-774-HURT. That's 1-844-774-HURT. Let's get you some money. Denial, admit the obvious. and deny the meat. Standard stuff. A lot of denials, copy and paste, count 12, count 13. And now come the affirmative defenses. Now, this is the fun part. Having denied each and every allegation pled in the complaint that has not been expressly admitted, Ms. Reed asserts the following affirmative defenses. The complaint fails to state a claim upon which relief can be granted, and accordingly, each count set forth therein should be dismissed with prejudice. To the extent that the plaintiffs have suffered damages, all such damages claimed were caused by the acts and omissions of third parties. Jennifer McCabe et al., for whom Ms. Reed is not responsible. The plaintiff's claims are barred by the doctrine of waiver. Their claims are also barred by the doctrine of estoppel, laches. These are archaic legal terms, but we're going to explain them in just a moment. The applicable statute of limitations has expired. The doctrine of unclean hands, that they themselves in some way, shape, or form contributed to the situation themselves, the plaintiffs, the O'Keefes. Any damages that the plaintiffs claim that they're entitled to are expressly limited by Massachusetts law, including the limitations on damages set forth in Massachusetts General Law, Section 229, etc. Plaintiffs fail to establish that they're entitled to punitive damages as claimed, and plaintiffs fail to establish that they're entitled to attorney's fees and costs as claimed, and they expressly reserve the right to assert additional affirmative defenses as this matter proceeds and as new facts come to light. Signed, Damon Seligson, October 21st, 2025. Okay. So let's go over some of these. The plaintiff's claims, this is number 3 on the affirmative defenses list. The doctrine of waiver is the voluntary and intentional relinquishment of a known right. What does that mean in human language, Larry? It simply means that you failed to assert something, therefore you waived it. Simple as that. If you didn't assert a right, you waive it. This means a person or party can choose to give up a legal right either through a clear express statement or through simple inaction with full knowledge that they do have that right and they fail to act on it. The doctrine of estoppel is the legal principle that prevents a party from asserting a claim or right that contradicts their previous actions, statement, or conduct. I imagine this is when they're going to argue that because Karen Reed was acquitted in the criminal trial, they didn't really have a right to bring this case in a civil arena, but I could be wrong. There are many different ways that this could be interpreted. We will see later as they extrapolate more information from this case. Now, the doctrine of laches, this is something that I haven't covered since law school. It's an equitable defense that bars a claim due to an unreasonable and inexcusable delay in asserting it, which causes prejudice to the other party. The O'Keefe's failure to file this lawsuit at the time that the injury and the death occurred to John O'Keefe basically should bar them from bringing the lawsuit later on down the road. It is a very, very seldom used doctrine for obvious reasons. The doctrine will only apply when you had the right, the need, the knowledge, and the facts to file something, and even though you're still within the statute of limitations, you actively chose not to file it for whatever reason. In this case, we obviously know they were waiting for a criminal conviction in the first trial, and when they didn't get it, they filed it anyway, waited for the second trial to be over, then when she won and they lost, they're like, okay, now let's get the civil case going. Even though they did try to depose Karen right before she started her second trial, which is abhorrent behavior. And of course, that fell apart very quickly. And of course, my favorite, the doctrine of unclean hands, the legal principle that prevents a party from seeking equitable relief from a court if they acted in some way in a dishonest, fraudulent, or inequitable way that is related to the subject of the lawsuit. And once again, it's because the O'Keefes, deep down, they know who caused the death of John O'Keefe. They know what is going on here. They know what happened, and they still insist and persist in their pursuit of what they're calling justice. Don't forget to like this video, comment below, subscribe to the channel. This is not justice, folks. Do you understand? They're going once again after a woman who has been acquitted not once but twice in Norfolk County. Twice she has been acquitted. And yet they're like, okay, we're just going to keep going. We're just going to keep going. And for what? Now, thankfully, we do have the O'Keefes to thank for the fact that now Damon Seligson, Alan Jackson, and the rest of the crew are going to drag by the hair the McAlberts into this lawsuit. And we're going to see that hopefully over the next few weeks before the next hearing in November. I'm very excited to see where this is all going to go, because there's no escape now. Not for Karen, for the McAlberts. They're being dragged into this lawsuit, and they're going to have to pay the price, the heavy price of now being the real third-party culprit, something that Auntie Bev Canoni failed to honor in the criminal case because she was corrupt along with Morrissey and trying to exclude as much of the real evidence as possible and try and focus on the poor innocent woman that was before the court, Karen Reed that is. And now there is no escape. Third-party defense is going to be alive and well, and we're finally going to see what we should have seen in 2024 and earlier this year in 2025, but now we're going to see it in action. So folks, I hope you all learned something. I love every single one of you, and I cannot wait to continue covering this lawsuit. Now today you see I have released not one but 2 videos because yesterday I was unable to record due to some personal things that we had to go through, so I do apologize for that. So I'm making it up to you today with not one but 2 videos, and I will see you all tomorrow. Bye everybody.